Judgment in the matter of Fimbank against KCH Shipping Co Ltd.
The international carriage of goods by sea is almost invariably governed either by the Hague Rules, a 1924 international convention for the unification of rules of law relating to bills of lading, or the Hague Visby Rules, the Hague Rules as amended by the 1968 Brussels Protocol. Both the Hague Rules and the Hague Visby Rules provide in Article 3, Rule 6, that the carrier will be discharged from, quote, all liability unless suit is brought within 1 year of the delivery of the goods or the date when they should have been delivered. The central issue on this appeal is whether this 1 year time limit applies to claims which arise after discharge of the goods from the vessel, and specifically to misdelivery claims. Misdelivery occurs where the carrier delivers the goods without production of the bill of lading to a person not entitled to receive them. By way of factual background, the claim for misdelivery relates to a cargo of approximately 85,000 metric tons of steam coal shipped aboard the vessel Giant Ace for carriage from Indonesia to India. The cargo was discharged from the vessel in India between the 11th and 18th of April 2018. Thereafter, it is alleged that the cargo was misdelivered. Arbitration proceedings were commenced on the 24th of April 2020, more than 12 months after the cargo should have been delivered. The respondent carrier alleges that the claim is time-barred by Article 3, Rule 6 of the Hague Visby Rules. The appellant's case is that the time bar does not apply to claims arising after discharge, since the carrier's responsibility under the rules ceases on discharge. This case was rejected by the Arbitration Tribunal, the High Court and the Court of Appeal, although for differing reasons. The Supreme Court unanimously dismisses the appeal. I give the judgment with which the other justices agree. It was common ground that in order to answer the main issue on the appeal, it is first necessary to consider whether Article 3, Rule 6 of the Hague Rules would apply to the claim. The appellant's key submission was that the period of responsibility provided for under the rules is limited to the period between the commencement of loading and the completion of discharge, and that the time bar equally relates, and relates only, to breaches of duty which occur during that period of responsibility. The court addressed that issue under the following headings: ordinary meaning, context, object and purpose, the travaux preparatoires, the English authorities, international case law, and textbooks and commentaries. The ordinary meaning of the language in the rule is widely expressed. The time bar applies, quote, in any event, to, quote, all liability, to claims, quote, in respect of loss or damage to the goods rather than to the goods, and it, quote, discharges liability, thereby extinguishing any claim. The context includes that the rule focuses on delivery, which in many cases will take place after discharge. It also addresses a number of matters which occur after discharge, such as the giving of notice of loss or damage, and joint surveys and inspections. The object and purpose of the time bar is finality. This is best met if all related claims are covered by the time bar. For the time bar to be dependent on the completion of discharge raises a number of practical difficulties, as the arbitrators found. The travaux provide indications that the time bar was meant to be as all-embracing as possible. The English authorities emphasise the wide wording of the rule, the importance of finality, and the undesirability of having a split regime of time limits. They have also applied the time bar to claims arising out of events occurring before loading, to goods which were never loaded, and to misdelivery claims arising prior to the completion of discharge. The international case law does not establish an international consensus. The textbooks and commentaries do not specifically address the issue. The court concluded that although the Hague Rules set out a period of responsibility during which the carrier is subject to minimum responsibilities and liabilities, which cannot be reduced, and entitled to maximum rights and immunities, which cannot be increased, the rules are not only concerned with that period. Other rules relate to the period before loading and after discharge, and Article 3, Rule 6 is concerned with the period up to delivery, including events which occur after discharge. The Hague Rules time bar therefore can, and does, apply to breaches of duty by the carrier which occur after discharge, but before or at the time of delivery, including misdelivery. It may equally apply to breaches of duty which occur before loading. In all such cases, it needs to be shown that the claim has a sufficient nexus with identifiable goods carried or to be carried. On this issue, the Court disagrees with the contrary conclusion reached by the Court of Appeal. If the Hague Rules time bar applies to misdelivery occurring after discharge, then the Hague Visby Rules time bar necessarily does so, given its wider wording, which refers to all liability, quote, whatsoever, and to claims, quote, in respect of goods. This is further borne out by the addition of Article 4 bis and the travo. On this issue, the Court agrees with the Court of Appeal. The Court rejected a further argument of the appellants that Clause 2C of the Bills of Lading had the effect of disapplying the provisions of the Hague Visby Rules, including the time bar, to events occurring after discharge was completed. The Court therefore concludes that both the Hague Rules and the Hague Visby Rules time bars apply to claims for misdelivery occurring after discharge, and the appeal is accordingly dismissed. The Court is now adjourned.